Hey, welcome everybody. Another hot summer day. It's June. We are doing our quarterly review of the latest commercial and ag lending disputes. I'm Mike Fielding. Joining me today are my colleagues Chris Miles and Joe Price. Chris and I do insolvency work, and Joe's on the front end of deals. He's does lending related work, but he's on the front side when there aren't any disputes or everything's going hunky dory. So we're glad to have the corporate kind of front end perspective on our call today. I have a little script that I need to read while we have people just logging in. Before we begin, I'd like to cover a few housekeeping items. At the bottom of your audience console, there are multiple application icons for your use during the program today. If you have any questions during the webcast, please submit them via the question box. We will try to answer all questions during the webcast today. But if a fuller answer is needed or we run out of time, it will be answered later via email. A PDF presentation is available in the program materials folder. For those of you that are attorneys, this program has been approved for legal education hours for live attendees. You will report your hours by clicking on the CEU icon at the bottom of the screen. A certificate of attendance, including the course numbers, will be emailed to you tomorrow, along with a recording of the webcast for watching and sharing. And I had to think, sometimes your teenagers just won't listen to you. They just want to stare at the screens. And I thought, man, if I wanted to give my kids a punishment, maybe I would just make them watch this. And then maybe they would say, okay, have mercy on me. I'll do the chores like you've asked me to do. Anyway, toward the end of the program, be sure to complete our short survey. We use your feedback to plan future programs that are applicable to your business needs. Now, that's all for the housekeeping items, and we will get started. So just as I've said before at the beginning of all of these webinars, every day I get a listing of the latest cases coming out on commercial and ag lending disputes. I look at kind of the headline synopses and say, oh, that's really interesting, and then I literally get it and I throw it in a pile, and then I periodically go through them, and then we come up with what we do and we put in these quiz formats. Now the point here of the quiz formats is A, to talk about kind of the latest commercial cases going on, commercial and ag cases, but B, and I think more importantly, what we're looking here is to try to get practical pointers, things that empower you to better deal with troubled loans, that sort of a situation. So with that, there's a lot of cases here today. We have a ton of cases in the noteworthy section. We're just going to run out of time. I'll just warn you up front about that. So I better shut up and jump into the first quiz. All right, so here we go. So we're going to start with an easy one. This is a case coming out of Ohio, and you had a lender that had a properly perfected security interest in a bank account. This buyer is buying goods from some third party. The buyer stiffs the third party gets a judgment, and then attempts to garnish the bank account. Now, here's where it gets interesting. The bank, I should say, the bank, the lender, it's over here, and the bank account's actually at a third party lender. And there is, just in case you're curious, there is a deposit account control agreement with that third party lender. So the bank, the secured lender, is truly perfected in the account. So the third-party bank gets the garnishment. The third-party bank, then transfers the monies to the court clerk, and this judgment creditor says, hey, guess what? By transferring those monies, it's somehow stripped away the lender's lien. And that's the question. Does the transfer of the funds to the court strip the lender of its lien in the bank account? What do you think? All right, let you mentally pause. Well, the answer is it didn't. And the court said, listen, the third party's garnishment does not make the lender a transferee of funds under UCC Article 9, which kind of makes sense because this is not like a transfer in the ordinary course of business. And similarly, the clerk of the court getting the cash was also not a transferee of the funds either. So therefore, the lender's lien remains intact and the lender prevails, right? Hooray, right? We're happy for that. Now, what are the practical takeaways here? The first one is what I mentioned at the beginning. If you have a deposit account control agreement, the key thing that you need, excuse me, if your lender has its account with a third party, you need to be absolutely certain that you have a deposit account control agreement, because if you don't, when that cash is going to that third party bank, your lien is not going to be attaching to those proceeds. And then on the second bullet point, and I know I've mentioned this in past webinars, and this is a point that I think is super, super important. And I'll just say, as a threshold matter, a lot of the quizzes today, it's going to be what I'll call getting back to basics. And this is one of these get back to basics. And this basic point right here is that you need to remember and make sure that your collateral is perfected at each step. I think sometimes we fall into this mindset of, oh, I'll just get a UCC security agreement, I'll file my UCC financing statement, boom, I'm perfected. Well, that does a lot of it, but it doesn't do everything. And it's important when you start thinking about what is your collateral, you need to think through and follow your collateral along the line. Kind of like, Einstein jumping on his little light beam and riding it. When you jump on your collateral, so to speak, and ride your collateral, you're going to find that your collateral may actually change, right? And you can see, excuse me, here on the third bullet point, it may be materials. Those materials may then be turned into inventory. That inventory is then sold. So now your collateral has now been turned into AR. The AR is then collected. So now it's been turned into cash. And so you can see how your collateral is transformed at these different steps. And the key thing is you need to make sure that as your collateral is being transformed, you need to make sure that you are perfected at each point along the way. And so and we need to remember, obviously there's special rules for perfection, like titled vehicles. You need to file something with the Department of Revenue, real estate, obviously real estate filing, but like farm products. Well, if you're doing farm products, you have to, under the Food Security Act, you need to be putting out your Food Security Act notice if you're not in a centralized filing state. And if you're in a centralized filing state, you need to do your filing there. Obviously, IP, intellectual property, you're going to have perfection rules related there. So that's the key basic practical takeaway here. Think through each step and say, am I perfected? And I will tell you, it's better to do this up front when you're at the underwriting phase. When you get into the troubled loan phase, you can still make corrections if your borrower is willing to work with you, but it's not as clean, and it's better to do it right at the outset. All right, let's jump to the next one. Chris, breach of peace. Sounds like a little kid crying at night. All right.
Thanks, Mike. Here's the question. A consumer borrower defaults on a car loan and the bank sends an employee to repossess the vehicle at the borrower's home. During the repossession, the borrower runs outside, verbally objects to the repossession, stands in front of the tow truck and calls the police. The police arrive and tell the borrower that the bank is entitled to take the car, and the bank does. The consumer sues the bank for conversion and violations of the Federal Debt Collection Practices Act. The bank moves to dismiss on the basis that it did not breach the peace. Who prevails? The bank. And in this particular case, the bank prevailed because the borrower's complaint centered all on what the borrower did. And the court said that's the incorrect analysis. We are looking solely at what the bank did. Now, the third bullet point here is that professionalism is king. The court took note that the bank's employee did in fact stick around and get a dispensation from the police, which legally the bank, as a technical matter, did not have to do, but it's just a good idea. Who knows if the police had been called and the bank employee had just hopped in the car and driven off, the bank might still have won. But why not take the extra 15 minutes? Because if you've had any familiarity with breach of the peace cases, they can get pretty gnarly. And there are quite a few cases that it's almost shocking what courts will allow lenders to get away with, but you don't want to be that lender. You don't want to be walking up, tiptoeing to the line. So if you have employees or agents engaged in non-judicial repossession of collateral, again, the key is to never respond abusively to a borrower who's objecting, and caution and professionalism have to carry the day. And if your people conduct themselves that way, you will not get hung up on a breach of the peace under the UCC. So I'll let Joe take the next one.
Thanks, Chris. So the third case that we'll discuss today is out of Arizona. And some background on this, a borrower was seeking to purchase shares of a company to take over. They obtained a $3 million loan from Sunflower Bank. The loan was secured by a security interest in all assets of the company, and including, important here, all insurance proceeds and insurance refunds relating to the assets. In addition to that, what is commonly required is that the bank was required to be a lender, get a lender loss payable endorsement on the borrower's insurance policy. So following closing, the borrower and bank worked together, asked the insurance company to issue that endorsement. Due to some sort of administrative error, the bank, Sunflower Bank, was never listed as a loss payee on the insurance policy. So the question here, following a fire and loss of essentially all the collateral of the borrower, was the bank still secured in the interests of the proceeds of the insurance policy, even though they were not listed as a loss payee? And the outcome was yes. The bank had a perfected first priority interest in the borrower's assets. Those assets included the proceeds of the insurance policy. And one further step that the court took was that they reformed the insurance policy to name the bank as the loss payee, essentially because it was an insurance company administrative mistake as opposed to the borrower or the bank doing something wrong. So 3 takeaways that we had from this case is to make sure that your borrower is actually listing the bank as a loss payee or getting the appropriate endorsements as required. I know it's really common to say that that's a requirement, but actually thinking about taking the step further and seeing the endorsement to make sure that everything checks out can protect in the unlikely scenario that a fire causes a loss to the entire business. The second takeaway is that insurance proceeds can be included in security for the loan. It's common to list that specifically, say in a security agreement, all assets, list everything out, and then say insurance or proceeds of the foregoing. That's always a good thing to do to make sure that you're protected and getting a lien on those insurance proceeds. And then the third takeaway would be always making sure that your borrower is maintaining insurance and appropriate levels of insurance on their collateral. So that takes us through question 3. I will give it over to Mike.
Let me just make one other comment on this one, Joe. I think just so everybody has this in mind, you'll see that the bank, actually not the bank, the court reformed the policy because the fault was with the insurance company. So in other words, the insurance company dropped the ball. The thing you need to be cautious about here is what if the borrower says, yeah, I'll get to it, but the borrower actually doesn't have any intent to do that. And then you get into this fight later on where the bank's not named as loss payee, and the borrower comes back and says, yeah, I just breached my agreement. I didn't really intend to do it. Well, number one, you would argue there's the intent there because it's said in the agreement itself, i.e. I agree to name you as loss payee. That's going to be the first thing. But if you get into a situation where you haven't been named as loss payee, and let's face it, there's borrowers out there, they sign the deal, they get your cash, and then they kind of want to start breaching all these little minor provisions in the loan documents, basically seeing how far, what they can do, how much they can get away with. I think the key thing there is kind of press on the borrower and say, listen, you need to name me as loss payee, and I want you to send an email to your broker or to your insurance carrier saying, name the bank as loss payee, and press them to do that. And most of them probably would, and make sure they copy you on that email. they send it, and then you can respond and say, yes, this is what the parties agree to, right? So if you do that, then what you have done is you have created this evidentiary chain of establishing that there is intent by both parties to name the bank as loss payee on the policy. That way, if the carrier screws up and something happens, you could then run into court and say, hey, I have this piece of paper. Guess what? This is what the parties agreed to do. Judge, give me the insurance proceeds. So, all right, let's jump over here to the next one. Number 4, this is also a loss payee question. This arises in a Chapter 13 case. Don't be fooled by this, because this principle can apply also in a Chapter 11 on commercial and ag loans. So here you have, this is a case out of Chicago. You have a typical situation. You have a car loan. The loan requires that the debtor has insurance and name the lender as loss payee. The debtor files for Chapter 13, and the debtor provides proof of insurance, but the lender is not named as loss payee on the policy. And maybe they do that deliberately, hoping to try to, kind of pocket the proceeds. Again, this goes back to that point I made earlier. Make sure you are perfected at each step along the way. And one of the kind of quasi ways to be perfected is making sure you are named as the loss payee on the policy. That's an important point here. So the question is, the debtor doesn't provide this loss payee status. The lender objects to the plan. Who's going to win, the debtor or the lender? Well, we think about it. We jump over to the next one. The answer is the lender, because the loan documents explicitly required that the insurance had to be on the vehicle, and the lender was supposed to be named as loss payee. And so the court sustained the objection to the plan, right? It's one thing to maybe get a loan document and bankruptcy modify the terms of repayment. That's obviously very common in a Chapter 11 plan, but it's extremely uncommon to say, well, we're not going to even provide coverage to the lender for that. So obviously this is going to apply to Chapter 11. One of the practical things that I like to do is whenever a bankruptcy is filed, there's obviously questions about, do we have current insurance certificates? So whenever a case is filed, I like to always at the outset of the case send a letter to the borrower's counsel saying, please provide me within 2 or 3 days a copy of the insurance documents demonstrating that I, the lender, am named as loss payee on the policy. If they fail to do that, then you might have grounds to go into the bankruptcy court and argue for relief from the automatic stay or seeking some sort of adequate protection, because you have a borrower who's clearly needing to keep you insured but isn't doing that. And if they're unable to produce the documents, then you can, use that against them. All right, let's jump to the next one. Chris, number 5.
Thanks, Mike. A mortgage loan is transferred several times. During the several transfers of the loan, the note is endorsed in blank. And I'm going to pause here for a little refresher for those who don't remember. A negotiable instrument under the UCC, like a promissory note that backs or is backed by a mortgage or deed of trust, can be endorsed one of 2 ways. If it is simply signed, or signed and saying pay to the order of, and then just a line and no name identified, no payee identified, that is endorsed in blank. And that creates bearer paper, which means that whoever is holding the note holds the physical original note. They are the holder. They have the right to enforce the note and the mortgage. This is why your grandmother, when she wrote you a check for your 10th birthday, said, don't sign the back until you get to the bank, because she did not want you to create bearer paper and lose the check. The other is...
that's what Grandma wanted, right, Chris? Yeah. That's all that Grandma wanted.
All the millennials on the call have no idea what I'm talking about. Anyway, the other is payable to order, which is where you actually endorse it to a particular party. And given how often the servicing of mortgage loans is moved around, often you will see notes endorsed in blank, because that way when a tranche of loans, say 1,000 or 10,000 loans is transferred, the clerk doesn't have to go through each collateral file and stamp and then write in who it's being paid to. They can simply have a bunch of bearer paper, and then they physically just transfer it to to whoever purchased that package of loans. So getting back to the example, the deed of trust is assigned several times, and it more or less, in this case, followed whoever had the note, and those assignments are recorded with the county. The current servicer of the loan threatens to enforce the loan. Now, the servicer and the ultimate holder of the loan or owner of the loan is often not the same party, and in this particular case, they were different parties. In this case, the borrower sues, claiming the fact that the server is not listed on the deed of trust assignment renders the loan unenforceable by the servicer. Servicer moves for judgment on the pleadings. What result? The mortgage servicer prevails. It can enforce the note and the deed of trust. Much of this was litigated in the wake of the foreclosure crisis. These types of issues we're starting to see more and more as foreclosures of residential properties are slowly on the rise. And so some takeaways of this, which are a little different than the facts of the case, but very occasionally you will, if a note's been transferred a number of times, you'll have a holder or a holder's servicer, and several people back in the chain have not bothered to actually record the assignments. Now that doesn't render them the loan unenforceable, because the holder of the note has the right to enforce the mortgage or deed of trust. But it's a good practice, and it doesn't allow the plaintiff's bar a foothold to claim that these loans are unenforceable. And the other takeaway is make sure your collateral file is in good order. So make sure those assignments are recorded. Make sure the chain of endorsements is proper. And if you have if it has gone to, say, a servicer or even a local collection firm, make sure you have Bailey letters saying this is the original note and I placed it in trusted physical possession of it in so-and-so's possession. So with that, I will hand it back over to Joe, I believe.
Thanks, Chris. So I'll start with background on this case as well. It arises out of a bankruptcy, Chapter 7, filed by the trustee. So the Moon entities operated several lines of business relating to landscape construction and management. They obtained a line of credit that was secured by accounts receivable of the various companies from Core Capital. And the way that the business operated made the entities very dependent on Core making the advances when requested in order to pay short-term expenses, payroll, that sort of thing, as they became due. An important piece of this case was that the credit agreement contained specific language that made advances specifically at the sole discretion of Core. Eventually, the Moon entities got into a bit of financial trouble. Core sensed this and refused to advance on the line of credit. This kind of caused a domino effect that caused some other defaults by the Moon entities. And at the end of the day, the Moon entities tried to argue that Core acted in bad faith by basically refusing to advance on the line of credit that they had entered into. So the main question here was, can the lender cease making advances on line of credit without providing prior notice or an opportunity to find alternative financing? And the answer to that question is yes, the lender can do that. The language in the loan agreement gave the lender full discretion to cease advances regardless of any breach by the borrower. And another important wrinkle here was that there was no good faith requirement in the loan agreement. And the court found, at least in Maryland, that the borrower was not protected by an implied duty of good faith and fair dealing. So that is kind of an important piece here. The implied duty of good faith would have required the lender to exercise good faith in exercising its contractual obligations, but would not require the lender to take affirmative steps outside of what is in the contract in exercising good faith. So basically what the court found was the agreement said they could stop making advances. There was no good faith requirement within the four corners of the document. And so the lender was well within its rights to cease making advances, and the Moon entities did not have any sort of claim for breach against the lender. And I think an important distinction here as well is if there was an express duty of good faith, it may have altered the outcome and allowed the borrower to win on their argument. So our takeaways is that an implied duty of good faith applies to the contractual obligations, what's actually in the agreement, and does not create additional steps and requirements for a lender to follow. If you're on the borrower side, it may be a good idea to negotiate for some sort of express good faith protection to prevent this sort of thing. For example, instead of giving the lender full discretion and their sole discretion to cease advances, make it in their reasonable discretion, add some sort of good faith qualifier that would allow the borrower a little bit more protection there. And then an overall takeaway would be that the borrower should negotiate for what they are looking for with respect to protection rather than trying to fall back and look to legal protections on the back end once things fall apart. With that, we will move to question 7.
Actually, I can't help myself but comment, Joe. I got to add a few other points on this. This is a good one to think about. And a couple additional takeaways just as I'm listening to Joe that come to mind are, one, having this kind of sole discretion language in a forbearance agreement is especially helpful. It's one thing that your loan documents may build it in, but when you get to the forbearance stage, we want to try to remove that language if possible. The risk is even if you have the sole discretion language, especially when you're dealing with a line of credit, I mean, if you cut that off, you may just be, putting the company immediately into a liquidation position. And that's a tough decision because then the going concern value may just immediately evaporate. And then you're going to really be looking at the tangible hard collateral to try to get repaid. So that's always a tough decision. I think there's wisdom in the sense of signaling ahead of time of, hey, you need to step up or make these corrections. And if you don't, we will exercise this and just cut off the line of credit. So you're not just doing it out of the blue, but essentially giving warning or, in the kind of the back and forth that's going on. I think a bigger issue, though, that concern is lender liability related issues. And a common phrase in some loan documents is that the lender reasonably believes itself to be insecure. Now, as an aside, that sounds like something that somebody who attended junior high wrote, right? They reasonably believe they're to be insecure. But that, I think, if you have language like that in a loan document that's reasonably believes, that opens yourself up to some attack. Was it reasonable? Was it not? So you want to closely review your documents if you're going to make the decision to cut off the line of credit to make sure you have this absolute or unfettered right to do it. All right, let's jump to the next one. This is another bankruptcy one. This case comes out of Fifth Circuit. The New York and Delaware, they used to be the bankruptcy capitals of the world, but I'll tell you, in the last 2, 3, 4 years, the Fifth Circuit, Texas, especially Houston, has actually become kind of the bankruptcy capital here in the United States. So when you get a case coming out of the Fifth Circuit, which is where Texas is at, you really need to pay attention to it. Here you had a situation, you get a Chapter 11 filed. There's this broker that has some contingent claim against the debtor. The broker basically, there's always a concern about filing a proof of claim because the argument is if you file a proof of claim, you've waived your right to a jury trial. So this broker knows about the bankruptcy, doesn't file anything. The broker realizes that the debtor might also have a claim against the broker. So there's this possibility of the claims going both ways. The debtor gets a plan confirmed. The debtor's assets are then transferred to this liquidating trust who, pursues causes of action. That's extremely common in these liquidation scenarios. And the broker says, hey, I have set-off rights. I should prevail. And the question is, does that work? Because the plan specifically bars recoupment or set-off. Well, what do you think? Well, the answer here is the liquidating trust wins. And the reason is because the broker had actual knowledge about the case and did nothing to stop the plan or object to the plan. And then the court also says, and listen, even if that wasn't the case, the assets or the cause of action has now been transferred to a third party. Set off is only between broker and the debtor, but this cause of action has now been transferred to this third party. Therefore, set off doesn't work. And you could debate the propriety of that. That just seemed to be more of a statement by the Fifth Circuit, essentially trying to buttress its position, but nonetheless, it's a Fifth Circuit decision, so it's going to be out there. So the question is, what do you do with a case like this? Well, there's this, the idea of speak now or forever hold your peace. When you get into a bankruptcy proceeding, that principle is very much alive and well if you have actual knowledge about the case. And where you need to be particularly careful is, in my experience over the years, you get a Chapter 11 plan filed. Everybody says, all right, what's my distribution? How's my claim going to be treated? And that's good. You need to look at that. But then they always forget the other half of the plan document, which is where you have all this boilerplate stuff that just puts you to sleep trying to read through it. And that's oftentimes where some items are buried deep that could come back and haunt you. Like in this case, they had these provisions that barred the right of recoupment or set off. So, in hindsight, what should this broker have done? The broker should have filed an objection. The sad thing is, my guess is the bankruptcy court probably would have overruled it, or potentially sometimes if you file a limited objection, sometimes to get the plan confirmed, they'll do a carve out where maybe they say the right of set off is preserved in this one instance. So filing an objection is the safer thing to do. And obviously, if you don't object, especially when you know about it, you may run the big risk of ultimately being deemed to be barred by the confirmed plan. All right, Chris, the imposter rule.
Unmute there. Thank you, Mike. Two litigants settle a dispute. The defendant's lawyer receives fraudulent wire instructions and sends funds to a third-party fraudster. Plaintiff, not having received the funds, moves to enforce the settlement agreement. The Court of Appeals considered who should bear the risk of loss under the circumstances. And what result? Applying the imposter rule, which states that the risk of loss lies with the person in the best position to detect the fraud, the court held that the defendant was in the best position to detect the fraud because it had failed to take steps to verify the wiring instructions. So fairly straightforward here. Some of the things I do is I always send wiring information via, or I receive it rather, when I'm drafting settlement agreements via secure link. And I always let the other side know if I'm the sender, if it's coming, and let me know if it arrives. Another thing you can do, it's not in the bullet points here, but actually putting the wiring instructions into the body of your settlement agreement. Again, when you do that, you need to be careful about just sending it over normal email. Best practice in that particular case, if you have that sort of sensitive information, is to send draft settlement agreements back and forth between the parties via secure link. And again, the best practices are to always keep in contact with the other side when money is going to be exchanging hands, so you can avoid situations like the one in this particular case. So I will hand it off again to Joe.
Thanks, Chris. Case 9 is a case that comes out of the Supreme Court of Mississippi. It has a long and kind of convoluted history, but essentially it boils down to a dispute between different business partners in a medical practice. And it led to numerous lawsuits spanning several years. And it all kind of culminated in the parties finally agreeing to go to mediation. During the mediation, the parties agreed at a high level to different terms that they would be willing to accept. Things like payment for money pursuant to a promissory note, a non-compete agreement for one of the business partners, and the division of accounts receivable for a period of X number of months that would go kind of to the different parties. Important things that they left open would relating to the promissory note, which is kind of the key focus of this case, was the interest rate on the note and the time period in which they would be able to pay. The terms were written down by the mediator, and the parties agreed to essentially agree on a later date on the remaining items. Fast forward, one of the parties refused to sign a settlement agreement, and the other party filed to enforce what the mediator had written down, essentially saying that that was a binding agreement that everyone had agreed to. The lower court granted the motion to enforce the settlement statement, finding that the parties had reached an agreement and that they were sufficiently certain in order to allow enforcement. So the question here is, has an enforceable agreement, by that the high-level mediation terms, been reached between the parties? And the Supreme Court of Mississippi found that there was not an agreement reached between the parties. Essentially, they said, in order to be enforceable, an agreement must contain all essential terms. Whether a term is essential to an agreement depends on the circumstances. And in this instance, the missing interest rate and time frame for repayment on the promissory note was an essential term, and therefore there was not a binding agreement. So our takeaways from this case are: an enforceable agreement is not reached until all essential terms are agreed upon. That is likely to be a fact-based determination and can totally vary on a ton of different circumstances. So essentially, you just need to review and think carefully about whether you've created an agreement to agree or whether some very important thing is missing that would not allow for enforcement. The second takeaway is anything that you want enforceable should be included in writing. So that is case 9. I'll give it over to Mike.
All right. And sorry, I just can't help but comment again. So somebody listening to this, they'll remember the webinar we did 3 months ago where we talked about this very concept of a mediation statement and writing down your key terms. And this is what the parties did, or they thought they did. But what Joe's saying here is that there's this promissory note and they didn't include the rate or the term of payments, which I know the lenders, you're sitting here saying, duh. And I get it. You know, that's oxygen that you breathe. That's like just the bread and butter. That's the essential thing. You would, it's lender malpractice if you didn't include that. But I think the point as we're thinking through this is, especially when you get into either litigation or you're working out a forbearance agreement and you're coming up with these term sheets, again, it's best practice like we talked about 3 months ago. Get that mediation statement signed or written down and then signed by both parties. But when you're doing it, you need to be asking yourself the very practical question. If this person on the other side reneges on the deal and doesn't come to an agreement, can I take this document as written and could I enforce it? And that's the practical question you need to say there or think to yourself as you're sitting there reading through it. And if you go through and I can say, yes, here are the core terms, and there is nothing that's left to be undecided in the future, then you probably have an enforceable agreement. Now, you could have a situation where, well, we can't agree on the interest rate, but we could say, you know, it'll be prime rate plus 2 percentage points or 200 basis points as published by the Wall Street Journal 6 months from now. All right, well, that's an objective determination that could be decided upon in that situation. But again, the question is, can you figure out those core basic terms? That's what you should be asking yourself. All right, let's jump to the next one. Cash collateral. It's a pretty big deal when you get into bankruptcy. Again, don't be befuddled by the fact that this is a Chapter 13 case, because the principles of this question absolutely will apply in Chapter 11. Who says, the law is just an idea, I'll do it. He takes the cash, he's using it in violation of the bankruptcy code. He's not giving adequate protection to the lender, in this case, the Massachusetts Department of Revenue. So then later on, somebody calls the debtor on that, even though the debtor's been abusing it, using the cash collateral in an improper way. And then they put in place a cash collateral order. But then again, guess what? The debtor violates it. So obviously everybody's getting frustrated at this stage. And the bankruptcy court decides to convert the case to Chapter 7, and the debtor appeals. Optimistic about how debtors fare, they're going to say yes, they will, because courts are biased. Well, in this case, no. The debtor does not win, and the appellate court comes back and says, listen, there is this two-step process. Was there cause? Did cause exist for these violations of the cash collateral order? And if so, the court can then decide, do I convert the case or dismiss it? And what happened here is the guy was just abusing the situation. And the bankruptcy court makes the right call, in my opinion, because if you dismiss it, then the person remains in control. They're going to continue just abusing the use of cash collateral. So the court converts it to Chapter 7, appoints a Chapter 7 trustee, thereby effectively taking the debtor out of control. So I think the right result in this case. Now, what are the practical takeaways if you are a lender in a Chapter 11 or a Chapter 12 proceeding? And the question is, obviously abuse of cash collateral can occur under the bankruptcy code if there is unauthorized use of the cash collateral. And this is the key term, that is substantially harmful. That's the language that's used in the bankruptcy code, substantially harmful to one or more creditors. Then the court must convert the case to Chapter 7 or dismiss it. So the question is this substantially harmful to you as a secured lender? Well, what I don't like about that language is that implies that if it's kind of harmful but not substantially harmful, then the court doesn't have to do it. And that bothers me because you have somebody who's clearly not doing what they should, clearly kind of abusing the system or the process and getting away with it. And just at my core, that strikes me as just wrong. But anyway, it is the language. I'm not Congress. I don't have the ability to change that. But if you are trying to protect yourself, this is the key language that you want to be trying to get at. We want to make sure that there is a good system in place where you can verify how the debtor is actually using cash collateral. That goes back to robust reporting, accurate reporting, getting timely information, and quite frankly, that there needs to be transparency involved in the process. And as you're thinking through this, we want to be, for example, when you get a new Chapter 11 filed and you are negotiating the cash collateral order, you need to be thinking, how can we put in place a structure that there was absolute transparent reporting to the bank, because you want to use that as a tripwire, that if that reporting is not occurring, that we can begin to argue that that's becoming substantially harmful to the lender. All right, let's move on to the next question.
All right, thank you, Mike. This one is very fact intensive. A company called Greyhawk takes out a loan which is guaranteed by its two owners, and those owners each owned 50%. The loan goes into default, and the lender, the first lender, assigns the loan to a company, PDQ, which is wholly owned by one of the Greyhawk 50% owners, a guy named Mr. Queen. As part of the transaction, PDQ obtains a loan from a second bank, Lender 2, and pledges the first loan as collateral, and with those loan proceeds pays off Lender 1. PDQ eventually sells all its assets except the loan assigned to it by Lender 1. Typo there, my apologies. The debt to Lender 2 having already been paid. PDQ assigns the loan to Mr. Queen in his personal capacity, who then assigns the loan to another company called Blue Water Bay. Blue Water Bay goes to enforce the guarantee against the other owner, the other 50% owner of Greyhawk. And that other owner claims that pursuant to the merger rule, his co-guarantor, and that's Mr. Queen, cannot purchase or be assigned his own obligation. And the resulting transaction should be deemed a satisfaction of the debt. The trial court grants summary judgment in favor of the co-guarantor, and Mr. Queen appeals. What result? The Court of Appeals does not agree. The obligations under the note and guarantees were not extinguished by merger when the note was transferred from the note holder to one of the guarantors of the note, because the plaintiff was not a guarantor of the debt, even though the loan had been owned by Mr. Queen at one time. So it's a very interesting case in as much as it leaves open the possibility for the argument that if Mr. Queen had held on to it in his personal capacity and tried to enforce it, there may have been issues with respect to merger. But our key takeaways there are in these complex transactions where parties may be, quote, wearing multiple hats. Maybe they're an equity holder as well as a lender or some kind of or at least one of their companies or a company that they control holds debt that's due to their own to their other company. It's very important to get consent of all the parties involved. And one of the points in this particular case, in the Blue Water case, is that the court noted that the other owner, not Mr. Queen, but the other owner that was contesting this series of transactions had notice that all of these transactions had happened. He was well aware of it from the time that the debt was originally purchased by PDQ. And so, again, key takeaways here: make sure notice is given. Consent is even better. In this case, again, he'd consented to the original assignment. And whenever these transactions happen, it does not hurt to have a guarantor reaffirm his or her obligations in a separate and new document so you don't run into trouble like this down the road. And with that, I'm actually handing it off, not to Joe this time, but back to Mike.
All right. We're going to talk about challenging the validity of notarized loan documents. So this case arose in a bankruptcy proceeding, but these principles here definitely apply outside of bankruptcy. You have a debtor who objects to the proof of claim, says, hey, the signatures on the note and the deed of trust look different. And I guess when you held them up face to face with one another, they were a little bit different. But the debtor doesn't put forth any other evidence to say that they are, were signed or that something funny was going on here. And both signatures were notarized. And so the question is, if the debtor says you have two notarized documents, but the signatures look demonstrably different, is that sufficient for the debtor to win? Well, the answer is no. The lender is going to win here because when you have a notarized document, there is what I call a very high presumption of legitimacy. And it's really hard to overcome that. You have to do it by clear and convincing evidence. And obviously, if you're going to do that, you need to say, hey, maybe after I signed it, there was fraud or alteration, something like that. So what are the takeaways? You can see in my first bullet point, this old saying that if you're serious about a relationship, put a ring on it. Well, the same principle applies. If you're serious about a signature, put a notarization on it to button it down. And I realize that, I had a case last year. It was dealing with a contract, but it was this very specific issue. The party I was representing, it was in an agricultural context. The party I was representing said, hey, we have a valid contract. And the other person was saying, I didn't sign that document. And there was a lot of circumstantial evidence suggesting that he, in fact, did. We ultimately settled it. But it was a painful reminder that when these cases can get very costly, just arguing over whether a signature is legitimate. So I get it that a lot of times in a lot of bank loans, it's not notarized. If you're executing and you have a notary there, it's very cheap insurance to get. But I would say, especially when you get into the context of a forbearance agreement, especially if you are dealing with somebody who's been a little bit shady or sleazy or questionable, I would highly recommend that you, that you get a notarization on your forbearance agreement, because a lot of times those forbearance agreements are going to contain a lot of waivers or other provisions that are frankly very helpful for the bank, and you want to get that notarization proving that the person actually agreed to it. If you want to take that one step further, let's say you're getting a consent judgment or a consent arbitration award. In a perfect scenario, you may want to get the notarization as well, again, showing that the person really is bound by it. All right, next one. Chris?
Thanks, Mike. Mortgage lender gives a loan to a borrower and loses the note and has no record of the note. Borrower brings a declaratory action against the mortgagee, seeking a declaration that the note and mortgage are deemed satisfied, as well as claiming that unjust enrichment for the mortgage payments that he did make. Mortgagee moves to dismiss. What result? Motion to dismiss is granted with leave to amend. The courts basically said, look, under lost note theory, we under the UCC, we do not have the authority to claim that the note and mortgage are, quote, deemed satisfied. All we're allowed to do is say that it's not enforceable. And so it's a relatively new case. So the borrower may win in this particular one. And wanted to point out a few extra facts here. This the party, the defendant here, the bank, was not the originating lender. And so you could see this going a lot of different ways, because apparently this bank not only doesn't have the original note, but it doesn't have a scan of it either. All that one could probably find is a deed of trust that was executed in favor of the originating lender. And so the bank has a real evidentiary problem here, because it was not the originating lender. No one in the bank has personal knowledge that of what the original loan might have been. And the bank may be left with arguments in equity, basically saying, well, you know, we bought this loan and we know these monies were advanced and the borrower took this loan out. And by the way, the borrower concedes that in his petition. And so once you're in equity land, you could very well see a court saying, well, bank, your remedy is going to have to be with the originating lender, whoever you bought this from. You have to, because they are, and anytime you transfer a promissory note, a negotiable instrument, there are what they call transfer warranties. And unless those were expressly waived, this bank bought an unenforceable loan. And the court may very well say, well, you've got to go look at the seller, whoever sold you this loan, that's where you need to go find your remedy. But as far as this borrower is concerned, you need to release this mortgage lien because you do not have an enforceable interest. So just a couple points there. When you're proving up a lost note, you have to post security. And that gets people very nervous, but fear not. In the mortgage context, if your note is backed up by real property collateral, that's security enough. At least that's what the official comments indicate. This is more an issue when you have an unsecured note. So I know we're running close on time, so I'm going to hand it back to Joe.
Thanks, Chris. I will move quickly through this one. So this case involves a towing company. The company purchased the tow truck with a loan from Huntington Bank, and in exchange granted a security interest in the vehicle. The loan went south and the bank repossessed the tow truck and sold it in a private sale for $73,000. The borrower challenged the sale as commercially unreasonable, and the basis was that the company had purchased the tow truck for a little over $119,000 2 years prior. So the question here was that, is the fact that the borrower purchased the tow truck for $119,000, $120,000 2 years prior sufficient to show that the sale was commercially unreasonable? Here, the court went to a two-part test that they used to evaluate whether a sale was commercially unreasonable. So first step, the seller has to show that it disposed of the collateral in compliance with the UCC. If they are able to do that, then the burden shifts to the contesting party to show specific evidence that the sale was commercially unreasonable. So following that analysis, the court found that no, the sale was not commercially unreasonable. the evidence of what the vehicle was purchased for prior was not sufficient evidence to show that the sale was commercially unreasonable. In addition to that, the borrower provided evidence of similar listings for vehicles that ranged from 91 to 118,000, and the court distinguished listings for vehicles from actual sale data as not being completed sales, and did not accept that as being specific enough evidence to show that the sales were commercially unreasonable. So some main points here. Conducting a private sale of collateral on its own would not be commercially unreasonable. It is always a good idea to send a borrower notice prior to conducting a sale, and make sure that you are getting offers from multiple sources and confirming that those offers are commensurate with an arm's length market transaction. One more quick plug that I'll add here. I found a couple examples of commercially unreasonable sales just to give somewhat of an idea of what that might look like. A court held that a sale of a vehicle for $150 when being valued at $2,800 4 months prior was unreasonable, as well as a failure to give borrower notice of a sale was unreasonable because the borrower would have been afforded the opportunity to bid on the collateral to purchase it back. So as these things go, very fact dependent, but follow your procedures, make sure that you're getting multiple offers, evaluating each offer for whether it's market, and you should be protected. Mike, I think you're next.
So I think it's me.
Actually, yeah,
Oh,
we
sorry.
got to speak through, Chris. We're up to
And
a couple more
a quick,
minutes.
and a quick point on the 10 days. The 10 days, if you're under the 10 days in terms of notice, the court will usually deem it unreasonable unless there are certain extenuating circumstances. So the classic example a lot of us learned in law school was there are apples that are rotting on the dock unless you sell them within 3 days or 4 days, or some kind of produce, some kind of imminently perishable item. Then you do not have to give the 10 days notice, but generally you have to. So on to another commercial reasonableness case. Lender takes as security certain interests in condominium projects. And these are not just interests in real property, by the way. These are intangible condominium interests. The borrower's default, the lender engages a firm to market and sell those interests in the properties at auction. So this is a public sale pursuant to Article 9 of the UCC. The firm maintains a data room for relevant documentation and advertises the sale 7 consecutive days in 2 local newspapers. By the way, they also gave the 10-day notice. 170 potential buyers sign NDAs to access the data room and the documents. The sale goes ahead and the borrowers sue, claiming commercial unreasonableness. And they claim what most borrowers will claim, or guarantors, which is that you didn't get enough money for these assets. So the court held that the sale of condominium interests under the UCC was commercially reasonable. And a big takeaway here is that the more money is at stake and the more exotic the asset, especially if the asset is exotic, the more marketing that you should do, and the more you should engage a reputable firm that will set up a data room, that will have potential buyers sign NDAs. And a quick point on this is a New York case. And so an exotic asset, you're in a financial center in New York, so you can probably get away with just advertising in a local newspaper. If you're in rural Kansas or rural Missouri, a local newspaper for an exotic asset is probably not going to cut it. Even here in Kansas City, when we've had particularly exotic assets to sell at an Article 9 sale, we will advertise them in the Wall Street Journal, the New York Times, the Chicago newspapers, things like that. Because again, the more financially sophisticated a community is, the more likely it is a court's going to say, okay, well, the parties and entities that would be likely to bid on these assets are in Chicago, LA, New York, et cetera, et cetera. So another thing is that marketing the asset properly will do much to prevent claims that the sale price was too low. And the court in this particular case made that very point. So I believe it's on to Mike. Yes.
Yeah, last one. And I know we're short on time, so I'm going to just speed through this. The gist of this one, you have a Chapter 13 debtor. Again, this could apply in a Chapter 11. They get really cute. They said, hey, we're going to just take that cash that we pay to unsecured creditors, and we're just actually going to speed up our amortization and pay it to our secured lender and get out of bankruptcy quicker. So, kudos to the debtors for thinking outside the box and trying to pay off the secured lenders, right? We always like that. The question is, can they get away with that? And the answer is no. And actually, the debtors get spanked by the court on this one. The case actually, the court says they're not proceeding in good faith. And the court actually goes ahead and dismisses the case. So obviously, if you get too cute with these repayment plans, it can backfire. The point, though, is when you get into these subchapter 5 bankruptcy cases where they do have to give disposable income, there's actually a good, legitimate argument that the debtor can hold back cash for capital improvements. And so if you're a secured lender in that case, this idea, maybe not necessarily of speeding up the amortization, but maybe holding back some of the cash that would go to unsecured creditors and using it to keep the business afloat, that actually has more legs under the wording of the statute. So just keep that one in mind if you are, dealing with one of these small business creditors. All right. Well, that does it for today's quiz. We've got a lot of other noteworthy cases at the end. You can get these in the materials. There were a boatload of cases this time. We obviously ran out of time to cover all these. I will tell you that the next quiz that we are going to do, or next summary, is going to be on Wednesday, September 25th. And so put that on the calendars. We'll send out an e-invite for that when we get close. So we want to thank you for joining us today. We hope the information was helpful to you. As a reminder, the program has been approved for legal education hours. To report your hours, click on the CEU icon at the bottom of the screen. A certificate of attendance, including course numbers, will be emailed to you tomorrow, along with a recording of the webcast for watching and sharing. Be sure to complete our short survey. We really appreciate that. We use the feedback as we're trying to do future webinars. And this concludes our webinar today. Thank you for joining us.